God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to this session of the Massachusetts Appeals Court. Is this on? It sounds a little bit different than normal. It might be volume control. Okay, maybe there you go. All right. Thank you, Judge Neyman. We have only two cases on the list this morning, both of which have been rescheduled from earlier days. I believe you probably all know the ground rules, but I'll state them very briefly, which is that each side receives 15 minutes to argue, and there's no rebuttal. We have read everyone's briefs, relevant portions of the appendices, so you do not need to feel that you must educate us on the background of your case. We are prepared to ask questions, and you can delve right into the issues. Of course, you may structure your argument any way you wish. I should have introduced the panel this morning. It's my great pleasure to be sitting with Judges Neyman and Shin, and my name is Gabrielle Wolohojian. I understand that in our first case, one of the parties who are the appellant, who is pro se, is not here. The case is 2022P 1106 in the matter of child, and it's a fully impounded case, so I'm not going to refer to any names, but I'll just refer to the appellant as father, and father has stated that he would be here today. He's told the clerk's office that. The clerk's office has made numerous attempts to contact him and have communications with him, and he has received notice of this morning's argument, and he has not appeared. I'm going to, so we will hear argument from the appellees, should the appellees wish, understanding that there's no argument on the other side. You are free to submit on the briefs if you'd like to, but of course you're free to make an argument if you'd wish. And with that, I'll just call the case, which is 2022P 1106 in the matter of child. As I have already stated, there'll be no argument from the appellant, pro se father, because he has not appeared despite notice. Does either of the appellants wish to be heard?
May it please the Court, I'm Madeline Blanchette and I represent the child. If I could just make a few remarks. The child asks that this panel please affirm in all respects the order of the lower court. As I argued in my brief, there are three principal reasons. Number one is that father's brief did not rise to the level of appellate argument. The second reason being that at the time of trial, father was unfit. That was clearly evidenced by what the lower court called troubling statements, which really it was very clear that father could not meet the complex needs, emotional needs of the child. The third issue is that the order was in the child's best interest. It was a nuanced order. The child is thriving in the care of his grandparents, where he resided even prior to the tragic death of his mother. And again, the child's position is not one of animus towards father. Father was granted, in fact, even an increase in visitation from the order, and it serves the child's best interest. Does the panel have any questions?
I'm going to check.
No.
No, but I'm also going to note that I assume that the father has now appeared in court, so I'm going to let him come sit at counsel table despite the fact that he is not here on time. We'll hear from him, and if you have anything you want to add beyond what you've said, we'll just give you a few more minutes if there's anything specific that you would like to rebut in what he said.
Thank you, Your Honor. Otherwise, I do rest on my...
Thank you very much.
Thank you.
Sir, if you would like to present any argument, you may do so. You go to the podium.
Good morning. My name is James Blake. I'm the father.
Sorry, just so we're clear, this case is impounded, which means that we're not supposed to use the names of any of the parties, so you can either use the word son,
I'm the father
child.
of the minor.
Thank you.
And the judge made the decision based on the fact that my son and I had not seen each other in so long. But that decision was based on us not seeing each other because we're being denied the time together. We're forcibly being kept from each other, even to this day. I would argue that, excuse me, I would argue that you have to excuse me for a second, please.
Absolutely.
I'm having trouble breathing.
It's okay. Take your time.
Yep. We have your brief. We've read the written materials that you've submitted. Arguing in court is very difficult even for lawyers, so we understand. You don't need to feel that you need to repeat everything in your brief. You can argue and tell us whatever you want. Take your time.
So we've been forcibly denied the right to see each other for years. This continues to this day. They have never followed court orders, never once, my son's grandparents. I would argue that the judge's decision was also a violation of my constitutional civil rights based on the 14th Amendment. And I'm sorry, I'm having trouble breathing.
It's okay.
It's okay. Do you feel that you need some medical help?
No, I don't think so. I think I just need to take a second.
Take your time. Would some water help you? There's
Yes,
water
please.
over there on the table.
Thank you.
There's a little, right.
Before all this happened, my son and I were as close as a father and son could possibly be. This was violated, or interrupted rather, when I let him go visit his grandparents for a visit while his mother was in the hospital. She had been hospitalized because she had been having an affair with a heroin addict that she worked with, and he had her shooting heroin, and she had received an infection from a dirty needle, I guess, that spread to her brain, and she got meningitis and had a stroke. So she had open heart surgery, and while this was all going on, I let my son go visit his grandparents. They tried to kidnap him a couple of weeks before that, and I had called the police. They went and got him back. Now, I'm thinking that the police would get him back again if this happens again. So I let him go again 2 weeks later, thinking that if anything happened, I can call the police, everything will be okay. Little did I know, she was out of the hospital, and because of this, I was told I do not have any custodial rights over my son, even though he lived with me and I was his sole provider and caretaker. And after that, they kept him and would not let me see him. I spent the next several years trying to work things out with my son's mother. She continued to lead me on and tell me that she wanted to be with me and wanted to work things out. And I didn't think it was the best idea for me to go to court and drag her into court and us to fight over him in court if we were going to settle things out of court. And that obviously didn't end up working out. So here we are today.
What is the current visitation schedule? Is there one?
Yes, I get 16 hours a month with my son, 2 hours a week on Wednesday afternoons, and every other Sunday I get 4 hours with him.
And are you doing those? Are those
Yes.
taking place?
When they show up for them, which is rare. So during these visits, my son and I, it's like we never skipped a beat. His birthday was last month. I didn't even get to see him on his birthday, even though our scheduled visit was that day. It just continues the same thing for the past 10 years that I've been dealing with. My son's grandparents just don't like me, and that's fine, but I'm still my son's father.
Let me see if there are any questions.
Thank you.
Do you have anything further you'd like to say?
I don't, Your Honor. It's all in my brief.
Okay, I appreciate it. We have your brief.
Thank you.
And, right, so our protocol here is, I don't know if you've been in the appeals court, you just stay at your table and you wait until all the arguments finished on both sides. But there's no rebuttal. We won't be returning to you. All right, counsel for child, Attorney Blanchette. You don't have anything further to add after that. Okay. Attorney White?
Good morning. May it please the court, I am Attorney Jennifer White and I represent the maternal grandparents. I echo my sister's arguments, being that father's brief did not rise to the level required for the appellate brief. Furthermore, father was unfit at the time of trial, and the lower court's finding was supported by clear and convincing evidence. The order was in the child's best interest. The child continues to reside with the maternal grandparents. He is thriving at home, socially, and excelling academically, and also in his extracurricular activities. The maternal grandparents ask that the court affirm in all respects rulings of the lower court.
I'm going to ask you the same question I asked the father. What's the story with visitation currently?
Currently, there is a court order requiring visitation with the child. The maternal grandparents bring the child every time. There's a very hostile and difficult relationship with father and specifically the maternal grandfather. But my clients bring the child to the visitation every single time. They were meeting at the police station and documenting it. So there should be much documentation to that.
And there are no proceedings below with respect to, enforcing the order for visitation?
No, there is not. I think there were 5 complaints for contempt brought, all denied for lack of my clients complying with the parenting time order, but none of them were ever acted upon. They were all, I believe, they were either denied or they just kind of, father didn't continue to pursue them. Then we have the trial, and then this order went in.
Okay, let me see if there are any further questions for you. All right, thank you as well. We have everyone's arguments in their briefs. We appreciate it. And with that, the case is submitted.
Thank you.
Thank you.
The next case is 23P0012, James TISBERT versus New England Mobile Crushing Services, Inc. All right, so is it Attorney McMillan?
Yes, Your Honor. Good morning.
Good morning. We're ready whenever you are.
Thank you. May it please the Court, I think the argument that I'd like to start with first is the issue of the timeliness of the appeal. The plaintiff has raised the issue that the only matters which should be heard by this Court are with respect to the amended judgment deals with the attorney's fees, and we obviously disagree with that. We have briefed that both in the primary brief. It was as an afterthought at the very end in light of the fact that the plaintiff filed a motion in the trial court, but then when he briefed it more, citing predominantly federal district court cases as opposed to state cases, we did decide to file a reply brief, and it's our position that as this panel may be well familiar with the case of Ebone, that it is an unsettled matter here in Massachusetts at a state court level. The Ross case dealt with the issue with respect to the fact that there was a bright line rule, but it was established for the federal district court, and they did not choose to expand that to be addressed and handled here in the state court. So it is our position that since it probably would be well to have a bright line rule, this may be the case to do it, and this may be one of first impression. However, if the court does decide that that's exactly what's going to be done, we would request that it be done prospectively so that everyone has notice of that going forward.
So the bright line rule would be that if you do file your notice of appeal only after an amended judgment where the amendment only pertains to attorney's fees, then you're only appealing the attorney's fees.
I wouldn't agree with that. I think in terms of
what other bright line would there be? That no matter when you file your notice of appeal, you encompass everything?
I think in terms of the economy of justice and being able to handle things, if one were to file a notice of appeal at the end of the entry of the first jury verdict and then have to go and do it a second time.
It's just a single piece of paper, and we see it all the time, that people file a notice of appeal from a judgment and then from an amended judgment.
I do agree that it can be somewhat straightforward, but I'm not advocating that the bright line be at the time of the...
So what other bright line would there be?
At the time that all the issues are dealt with, including the attorney's fees and any other post-assessments after the verdict.
But if final judgment, I mean, the rule normally is you appeal within 30, you have to file your notice of appeal within 30 days of the final judgment. You don't contend that there seems to be no dispute as to the date of final judgment.
In this case, the amended judgment date would be the end of the final judgment.
I don't know what you mean by end of final judgment. There's usually...
So there was a jury verdict entered in July.
Yeah.
And that was issued through a verdict, which is part of the record. Subsequent to that entry, there were some post-judgment motions.
But they're post-judgment. Judgment had already entered.
By the jury.
No, that the verdict entered by the jury, and then the court entered judgment.
Correct.
Right? There's a final judgment reflected on the docket. Am I correct?
The judgment, the amended, there is a judgment. I'm not getting the finesse here with regards to the semantics, but there is a jury verdict that was entered in July, yes.
And subsequent to that, there was a judgment entered.
Correct.
And then later after that, there was an amended judgment.
Yes. So that amended judgment is in fact the final judgment because it encompasses all of the issues that were raised in the lower court.
including the request to modify.
Do you have any case that says that even if a final judgment enters, if it's subsequently amended, that amended judgment is the, quote, final judgment?
I don't, and that's why we're here. That's why I'm contending that it is an issue of first impression with respect to this court. There are other jurisdictions which do allow for the appeal 30 days from the amended judgment, but in this particular instance, the position that I'm advocating for is that whatever judgment is entered, even if it's amended, even if it's just for attorney's fees, should be the triggering date for the filing of the notice of appeal 30 days beyond.
Well, how would that work? A judgment enters. It may or may not ever. What if the motion had been denied? What if post-judgment motions had been denied, and so no amended judgment ever entered? Would you then be able to just file a notice of appeal if no notice of appeal had been timely filed before?
No, because then the deadline would be that first.
It always was the deadline.
But then you have.
I don't know how we can assess these deadlines retrospectively, which is what it seems to me you're asking. In other words, at the time a party is needing to make the decision as to when to file the notice of appeal, isn't that the time we should be looking at? The party may not know that. I'm sorry, I'm not letting you have a chance to answer any of these questions, but let's just play this out. A judgment enters, parties needing to decide whether or not to file a notice of appeal. Party may not know. The party may not know whether or not there are going to be any post-judgment motions. Or they may know, but they may not know the timing. They may not know when the judge is going to rule on them. Doesn't the party need to file the notice of appeal from the judgment?
In this particular case, Your Honor, they knew that there was going to be a post-judgment motions because the plaintiff was seeking attorney's fees and costs. So that's a given. More importantly, you have the right to file post-judgment motions, judgment notwithstanding verdict, as we did in this case, and there was a motion to amend the findings on the damages because it did impact on the case as to whether there would be a change in the assessment of double to treble damages under the Wage Claim Act. That being the case, you knew that it was still active. The parties knew that it was still active at that particular juncture. So it's our position that until the amended if there is going to be an amended judgment, until that is filed, that should be the triggering date. Because the amounts would change, and they did change.
So if the judge had denied the post-judgment motions and there were no amended judgment, when should the notice of appeal have been filed?
Then it should have been 30 days after the date of the last motion, which told the filing.
All right, and so what's your authority for that?
Based on common understanding, the case law, the interpretation of this court.
Is there a case that you can give me for that proposition?
Of the time frame to file after the denial of the post-judgment motions, I think there might be one in the brief, but I can't recall off the top of my head, Your Honor. That to me was always there's certain, not all post-judgment motions.
There's certain.
But we did, I believe, the trial counsel filed for a modification of the judgment in addition to the judgment notwithstanding, and I believe both of those do toll the.
A Rule 59 and a Rule 60 can both toll it.
Yes. But I cannot think of a case right off the top of my head, Your Honor.
All right. Would you like to address any of the substantive arguments in your brief?
Yes, Your Honor. Obviously, without waiving all the in-depth analysis and issues that we raised in it, I would like to address the first argument, which is that this case should have been dismissed from the very start. Right off the bat, trial counsel maintained that this court did not have, the trial court did not have jurisdiction, wasn't a proper venue. After having an initial hearing in front of the judge, there was some additional supplementation in terms of the memorandum, and it seemed to indicate that the judge wanted some information with regards to, improper venue, forum nonconvenience, conflict of law. Trial counsel did it at every possible avenue. Every motion that he filed and every motion for reconsideration that he filed ended up getting denied. Unfortunately, as a result of that, the case was not thrown out and proceeded forward through the court system. The contract that is at dispute here is a contract that was formulated in New Hampshire. It was formulated between two New Hampshire residents. It dealt with the employment in New Hampshire. New Hampshire was the state with the most involvement.
Are you arguing? You said you wanted to reach your first issue. Your first issue, as I understand it, is personal jurisdiction. Is that correct?
But that then feeds over into the other arguments. The very next argument, I believe, addresses that the trial court erred when it denied the motion for reconsideration for improper venue, forum nonconvenience, and choice of law.
Okay, so which are you arguing right now, I guess is what I'm asking.
One has now, the first one is the contact in the jurisdiction, the lack of sufficient contacts with the...
And that's our traditional minimum contacts and due process.
Yes.
Okay. As to your choice of law argument, procedurally, when should the choice of law argument be brought?
It should be definitely brought before trial, and it was. It was brought in the supplemental motion when the trial judge indicated that he wanted additional information with respect to the forum nonconvenience and the choice of law. And that was, I believe, in July or August of 2018. It was brought up again when there was a pretrial conference in which the issue of the choice of law was again raised by trial counsel. And I do know that the endorsements that are contained on the docket indicate that these issues weren't brought up before, but if you look at the citations that we've put in there, we give specific references that the judge did acknowledge that there were choice of laws, that Attorney Joyle, who was the trial counsel, did raise it, but he, again, did not address it at that particular point in time.
On page 46 of your brief, you state that the parties agreed that the employment contract was governed by New Hampshire law, but you have no record citation to support that statement. Can you tell me where in the record I will find support for that statement?
Where are you citing from, Your Honor, please?
Page 46. It's the end of the first paragraph.
You mean a statement that was specifically made with regard...
That is a statement of fact, so I'm looking for a record citation to support it.
Well, the fact that both parties were New Hampshire residents...
No, but where do we see the agreement of the parties? I'm sorry to interrupt.
I will have to go back and get you one, Your Honor. I don't see it. Obviously isn't cited right there, but we'll go back through the transcripts.
So the choice of law argument you're raising now is not the same as the argument you made in a motion to dismiss for lack of personal jurisdiction or inconvenient forum. What you're saying now is that the portion of the damages that the jury found occurred in New Hampshire should not have been trebled under the Wage Act. When was that raised to the judge? Before the verdict?
Well, 2 times. I believe the first time, actually 3 times. First time when it was raised verbally at the pretrial conference. Second, when he filed a motion in limine to preclude any testimony.
The motion in limine was decided on the ground that all the evidence comes in for completeness, and that seems to be within the judge's discretion, right? So that didn't cover the legal issue. So you submitted, I saw on the record there were proposed jury instructions that would have excluded the damages in New Hampshire, but what happened there to those instructions? Because the instructions that were given were different. So what happened once you submitted your jury instructions?
I was not trial counsel,
okay.
So I don't know what happened between the submission and what the court actually ended up adopting. But I do know that trial counsel constantly argued that the...
Did he object after the instructions were given?
I don't have that off the top of my head, Your Honor.
Did he ever file any sort of objection to the verdict form?
Well, going back to your question, once the verdict was, and I know that they had some colloquy about what type of format they should use and a little back and forth. I don't know whether he actively objected to it, but I do know that when the verdict form came in and there were inconsistencies between the various findings.
Right, I understand that, but before the verdict came in, is there any place in the record where we can see an objection to the verdict form? The framing of the questions on the...
I don't recall that being true, Your Honor.
I have one question about issue 6. You claim that the trial judge erred when he denied your motion to set aside the verdict on the breach of the covenant of good faith and fair dealing claim. My understanding is the jury awarded no damages on that claim. So what is the remedy that you're seeking as to that claim?
I guess this was just a series of what we consider to be erroneous decisions by the trial judge. And just by way of example, the court is correct. I mean, there was no breach of contract found and there was no damages that were assessed. So no harm, no foul, I suppose.
Okay.
I'm trying to understand your choice of law argument a little bit more, or maybe I should say your Wage Act, your attack on the Wage Act. I have a couple hypotheticals for you, so I just want to see how you would come out on those. The first one is you have a Massachusetts employee and a Massachusetts company, Massachusetts-based company, and the employee is sent to New Hampshire to perform jobs. Does the Wage Act apply?
Well, as you know, the Wage Act is silent as to whether it goes extraterritorial. However, in that particular scenario, you're dealing with a Massachusetts company and a Massachusetts employee, which the Commonwealth of Massachusetts has an interest in protecting. It may apply. I guess it would depend upon the court that it goes in front of.
Okay. Let's say that we leave all of our facts the same as we have them in this case, except that instead of being asked to pick up any supplies or gas or oil or whatever it was and bringing it to the Massachusetts job site, the employee came straight to the Massachusetts job site and worked there during the day. But in the course of the day, he was sent to go to New Hampshire to pick up supplies and then bring them back to the job site. Would the Wage Act apply in that scenario?
Well,
or why wouldn't it?
It's a New Hampshire resident, though, right?
So is that your bright line, that if the employee is a New Hampshire resident, it doesn't matter where the work is being done?
It's a New Hampshire resident and a New Hampshire business, a New Hampshire contract, and you don't have a like New Hampshire action which would allow for treble damages and attorney's fees for violation of the wage.
So basically your rule, if I understand it correctly, would mean that any New Hampshire company right over the border could conduct all of its business in Massachusetts, but as long as its employees were New Hampshire residents, those employees would not be entitled to the benefits of the Massachusetts Wage Act, even though they did all of their work in Massachusetts.
Except that their employment was in New Hampshire. That's an extreme example, but
I'm trying to figure out what the implications of your argument are. So I take it that what I just laid out would be the case if we were to adopt your argument.
Well, the facts are different. So as we well know, when court make a decision on a particular case, they take those facts into consideration. From our perspective, since everything was New Hampshire, then it should have been dealt with by New Hampshire. The plaintiff could have filed, New Hampshire court system could have taken a claim to the Department of Labor. I mean, that is the more appropriate forum because New Hampshire has the interest in maintaining things on behalf of not only employees but employers and the businesses that run in New Hampshire.
Okay, I think we understand it. Let me see if there are any further questions. No. All right, your time has expired. Thank you.
Thank you, Your Honor.
Thank you.
Attorney Jacobs.
Yes, Your Honor. May it please the Court? This is a case, my brother in the reply brief argues that all the conduct relevant here occurred in New Hampshire. If this had been a case where all the work occurred in New Hampshire, this case would not be before the court. The work was performed in Massachusetts. New England Mobile Crushing sent Mr. TISBERT down to Massachusetts with a machine similar to an excavator that digs a trench, but instead of a bucket, it has a hammer on the end to hammer ledge at different residential and commercial sites so that they could use those sites more effectively, either for parking space or to expand the building, and wanted the ledge removed. He did all of that work in Massachusetts. But in order to do that work, that machine had to have fuel, it had to have grease, it had to have antifreeze, it had to have belts, it had to have hydraulic fluid. New England Mobile Crushing could have arranged for that to be delivered to the site and put in a locked storage. It could have gotten a permit to put a fuel truck on the site. Instead, it wanted Mr. TISBERT every day to bring all of that down to Massachusetts and then come back to the office, refill the fuel drum, get more grease or parts or supplies, and then go home. All of that work was not, as New England Mobile Crushing tries to argue, was not commuting. That was work for the benefit of the employer. The Wage Act 149, Section 1 defines employment, and it makes it clear that employment is anything done for the benefit of the employer in which all or the greater part of the work is done in the Commonwealth. It's not every bit. It can be the greater part. The greater part of his 8 or 10-hour workday was done in Massachusetts at multiple locations, which I cited in my brief, hammering in Massachusetts for New England Mobile Crushing.
Setting aside the question of how the Massachusetts Wage Act applies to these facts, can we take a step back and hear your argument about why it applies at all? If I take it your contention is, well, I'm not sure what your contention is. If a person is hired in New York, doesn't matter where the company is, it's just hired, it's a New York resident, let's say New York company, and it's a consulting type firm or, you know, some kind of firm that does jobs that last a certain period of time. So its employees are sent to wherever the consulting job is going to take place. And on this occasion, let's hypothesize that the employee is sent for 6 months to work in Massachusetts on a particular project. Is that person's compensation governed by the Massachusetts Wage Act?
I think if the work is done within Massachusetts under 223A, the Massachusetts long-arm statute, that work comes within purview of Massachusetts.
Well, it may be jurisdiction over the person, but I think it's different. The question of whether a statute applies is different than the question of whether there's jurisdiction over the person. So, do you have a case that helps us understand when the Massachusetts Wage Act applies to an employment or work situation where it's not as straightforward as, you know, it's a Massachusetts employee, a Massachusetts employer, and all the work is performed in Massachusetts? What's the best case for this notion that it applies at all if a person is sort of coming into the forum for a specific job? You know, it's like a period of time you're going to come in. You're being posted there temporarily.
Understood, Your Honor. I don't know that I can off the top assert a specific case.
Is there anything in the statute that helps us understand this?
Yes, I think the definitions of the statute on Section 3 define exactly what is employment, what is an employer, and what is work done, and the whole purpose of the wage, pardon me?
I didn't say anything.
Sorry. I thought I heard. The whole purpose of the Wage Act is to protect those people performing work within Massachusetts. It's designed also that people who work within Massachusetts, Department of Revenue collects a share of taxation for that. Those people are protected if there's an injury on the job. Those people come within the framework of Chapter 151B.
So any company anywhere in the country that sends an employee to Massachusetts to do any kind of work at all, no matter how temporary, is going to be subject to the provisions of the Wage Act?
I think if someone, for example, were hired by a Burger King in Salem, New Hampshire, by a franchisee who owned the Burger King and is a New Hampshire resident, and had that person come down to his North Andover store for a few hours to cover for someone, he would probably pay him out of New Hampshire and not come for those few hours.
Okay, so let's just take IBM or, you know, some other provider of equipment that is sold in Massachusetts, and they're running it and they need help at some point with a complicated repair. So the person is going to be sent from IBM out of state and comes here and has to spend 2 months at this Massachusetts company helping get their systems back up to place. The Wage Act's going to apply to that person.
I think Massachusetts reasonably can say that that person is now working within the Commonwealth, because otherwise, what prevents a company from, a New Hampshire company, a Connecticut company, a Rhode Island company, from saying, we're going to send all workers into Massachusetts, but we're going to pay them out of Rhode Island, not out of Massachusetts, but they'll be working at our site in Massachusetts.
Well, I guess the countervailing argument is what's going to then, if we adopt your interpretation, why would anyone do any business in Massachusetts? Why would anyone send someone to Massachusetts to repair a computer problem here?
Because they make revenue. They make revenue by charging the Massachusetts company that they are doing work for the fees and the costs of that worker coming into the state. No different than, in many cases, Department of Revenue will assess a taxation on someone who comes in to give a concert within Massachusetts for the income generated from that concert within Commonwealth of Massachusetts. That's happened more than once.
All right, so what authority, legal authority, do you have that spells out when some kind of contact with Massachusetts rises to the level that the Wage Act applies to it?
I did not find a specific case that spelled out that conflict when you're talking about multiple state work. The statute itself, 149, is designed to protect workers within Massachusetts performing work within the Commonwealth. Mr. TISBERT was physically in the Commonwealth, physically doing the work in the Commonwealth. He has to abide by the laws.
So is it a question of, it seems to me it's partly a question of fact, partly a question of law as to whether the particular conduct in the case is going to be sufficient to fall within the Wage Act. If the Wage Act doesn't have a bright line rule,
It does not.
then it seems to me some sort of mixed question of fact and law as to whether the Wage Act extends to the particular case. Would you agree with that?
I would not disagree with that, Your Honor. And I think
Okay,
Mr.
I'll
TISBERT-
take that as close enough to agreement. And then, that analysis does not appear to me to have been done below.
There was no request below by the trial counsel to do any choice of law analysis in this particular case, and that's one thing that the judge cited in his denial of some of the motions.
But weren't there motions filed? There was a motion to dismiss, which was subsequently supplemented with a request for a choice of law, for lack of a better term, and there were at least two other filings, at least that I read here, which argued choice of law and argued that New Hampshire law should apply to this case. So what do you mean by it wasn't raised? I'm having trouble reconciling the judge's order with the motions I see in the record appendix. Could you help me clarify?
The argument was made in the case below. There were about 4 motions to dismiss rather than just everything consolidated into one. So we had to sequentially oppose. One argument was because there was a New Hampshire company, New Hampshire resident, that Massachusetts had no say in it. It should be done in New Hampshire. New Hampshire has no interest in work done in the Commonwealth of Massachusetts. The Commonwealth of Massachusetts has its own Wage Act and its own Wage Act penalties to ensure that employers who employ people to perform work within the Commonwealth abide by the laws of the Commonwealth.
But that's different than saying that choice of law wasn't raised. You're simply saying that it was correctly denied.
There was no citation to cases arguing anything related to choice of law. The arguments that were made in the underlying case on the motion to dismiss were this case should be filed in New Hampshire, not that Massachusetts should use New Hampshire choice of law or any other choice of law. It should not be filed here because the individual company and the individual were residents of New Hampshire. It was totally ignoring the issue that all of the work that's being alleged and wasn't paid for in terms of wages was performed physically within Massachusetts.
There was no, I take your argument to be, there was no motion to dismiss or summary judgment on the merits of the claim. In other words, there was no motion ever filed saying the Wage Act claim fails on the merits because the Wage Act simply does not apply to the plaintiff.
That is my recollection, correct.
Okay. So what was the purpose on the verdict form of parsing out the amount of work done in Massachusetts versus New Hampshire?
I can't give you exactly the judge's reasoning, except we tried to give an explanation to the jury when we presented the case at trial on the amount of time that was involved going from Mr. TISBERT's house to Massachusetts and then from Massachusetts down to the job site, because we argued that all of his time in travel was not commuting time.
But it even parsed out the non-travel time for the overtime claim, right? So what's the purpose of that?
Because the overtime had to be parsed out because the travel time would not necessarily be overtime rate, it would be regular rate. And
right, but if the Wage Act applies to his work, it applies. It's not as though it applies to the work done in New Hampshire versus Massachusetts. I guess I'm just not understanding the purpose of parsing.
It was for trying to be able to calculate the amount of time, because the amount of time was the employer who was supposed to keep the time records never kept exact time records because he was not going to pay Mr. TISBERT for the work he was doing transporting all the materials. In addition, at trial, it became clear that the employer's books were altered so that he paid checks under things other than wages to hide the fact that he wasn't paying overtime rates for overtime work done within Massachusetts. And that came out at trial. The employer had to acknowledge that those books did not reflect accurately the wages and hours of the employee. So Mr. TISBERT was working all the time he was working, in the travel as well as in the hammering time, and then we had to parse out the overtime because it's a different rate than the regular time. But the original motions to dismiss were arguing the issue of should this case, does Massachusetts have a right to bring this case under the Wage Act because the work was done within Massachusetts? And the judge held, yes, Massachusetts has an interest in ensuring that people who perform work within the Commonwealth are paid consistent with the Wage Act. Then the issue became, well, should it have been dismissed from the Superior Court and held in the District Court? It would not have changed anything. It just would have been which venue, whether in District or Superior. When we started, we felt that the hours reflected, because we did not have the employer.
Was this your proposed verdict form, or was this something the judge came up with?
I'm sorry.
Was this your proposed verdict form, or did the judge?
This was the judge's verdict form. We both sides submitted suggested verdict forms, and the judge then.
And this doesn't conform with what you proposed?
This does not conform to what I originally submitted, to my recollection, nor what the opposing trial counsel submitted. The judge listened to the arguments that were held at the pretrial conference and then devised this verdict form. And his argument with respect to any inconsistencies, the jury did hold, with respect to the covenant of good faith and fair dealing, that there was a contract, and held that the covenant of good faith was violated. It didn't render any award there because the jury was instructed, if you've rendered damages elsewhere, do not repeat the damages in a subsequent finding. So the jury did not find any damages. What we don't know is whether the jury would have found damages there because of the unfairness of not having an accurate set of books and time records. We don't know that because the jury was not asked, because after the trial was held, no requests were made of the judge, so the jury was discharged and the judge left the bench. No requests, as Judge Karp indicated, were made of him to address any issues from the verdict slip or any questionable inconsistencies from the verdict slip.
I have a question about the timeliness of the appeal. Are any of the cases that you're relying on in your brief, do they involve a situation where the attorney's fees, where the amended judgment was only amended to add attorney's fees that were statutorily required by, that were statutorily required? In other words, the situation here seems to me a little bit odd because you know for a fact, both from all the way from the time of the complaint through the verdict and as required by the statute, that attorney's fees need to be awarded. So when the judgment enters after the verdict, you know that something's missing as a matter of law from that judgment. Do any of the cases you cite for the proposition that nonetheless a notice of appeal filed after the amended judgment is only appeals the amended judgment, the award of attorney's fees, involve a statutory scheme such as that?
In the case,
and I'm thinking it's like Chapter 93A,
correct,
the Wage Act. There are not that many, but the few statutes that there are, the anti-SLAPP statute, that
Barnum versus Massetti Development, which is an appellate court case, 2007, 68 Mass App Court 419, makes reference to the federal case, Budinich versus Becton Dixon, and it also makes comment that, and this was a 6F fees case. It's a
which is different. That wasn't what I was asking about.
The cases that we have seen.
I'm talking about statutorily mandated fees.
Correct.
I take it your answer might be no.
My recollection had been that the appeals court had rendered a case within the last several years, but we did extensive research and could not locate that case that said that once the judgment is final on the underlying case, that the appellate fee, the fee petition is corollary to that, and the appeal has to be filed within 30 days or an extended time if there are post-judgment motions within 10 days of the judgment. We would argue that that applies to this case because those are the appellate rules. Rule 4, it needs to be filed within 30 days of the judgment.
Okay.
Now,
Your time has expired, so I'm going to see if there are any further questions. No, thank you both. Thank you both for your able arguments and your briefs, which have helped us in this interesting case. And with that, the case is submitted. Attorney Jacobs, I take it we have a future member of the bar in the audience today?
We do, Your Honor. My grandson, Jonathan.
Well, welcome to you, Jonathan. We hope to see you here. You're dressed for the part already at some time in the future. Thank you for coming to observe.
Thank you, Your Honors.